Well, welcome everybody. Steve Denny here with Innovative Business Advisors. Glad to have you all this Thursday afternoon. This is our regular weekly update webinar, and we have got a, a very honored guest with us today. And unfortunately, you've just got me. So Marquita and Terry are both off in other pressing events this afternoon. So I'm going to be your host and moderator. Don't have much of an update to share with you this week. We'll do a quick chat, but I would encourage you, if you have questions through this really interesting presentation, please, if you will, add those to the Q&A box, which should be in the menu bar, typically on the bottom of your screen. So if you have any particular questions that come up, if you'll please add them there, we will definitely address those for you. As always, this webinar is being recorded. It will be transcribed and then uploaded over to our YouTube channel sometime within the next 48 hours. So we'll have copies of the presentation, and then you can get a full replay of the webinar over there. So with that, we're going to jump right in. This week, we are continuing to talk about survive, pivot, and thrive. Business owners that are making their way through this pandemic experience that we're all having with this wonderful foreign guest of ours. Hopefully we're on the tail end of this. School is beginning. Things are at least beginning to get back to some form of normal. And it's been kind of interesting. I've certainly marveled at watching both conventions as much time as I can over the last couple of weeks in the evenings, and boy, has that been a different experience. So it's amazing how everybody in every walk of life have had to make adjustments throughout this. But thank you all for participating with us. I do want to update you on a couple of the COVID aid updates. Again, as we had talked about last week, the SBA forgiveness portal is open. Banks are beginning to take forgiveness applications. We are hearing universally that if your PPP loan amount was $150,000 or less, that banks are asking you to wait until Congress finalizes the next level of legislation. That's due to the fact that several of the large banking lobbies are lobbying hard to get an exclusion, or I should say an automatic forgiveness of these what are considered to be small loan amounts. So if in fact that becomes part of the legislation, the forgiveness process for those that receive loans of right now it's in the working version of the law at $150,000. If you had a loan of $150 or less, you may be granted automatic forgiveness in that regard. So if you received a PPP loan of greater than $150,000, I would bet that your bank is probably encouraging you to fill out the paperwork and get started in the process. And banks are trying to get through this as quickly as they can. At least that's the feedback that we've been having from the folks that we've talked about. So that's about it. I will also remind you that there is still time to apply for a PPP loan if in fact you desire to do so. I met with somebody earlier this week that was not able to apply earlier because they had not filed all of their tax returns and didn't have the required documentation to make the filing, but they were in a process of getting that done and getting an application in before the window closes. So it is still available to you. Final update I'll mention is that jobless claims did tick down today. So we're back around 1 million, and that's a good thing for our economy as a whole. And as business owners, it's really a good thing from a standpoint of now's an outstanding time to be taking a look at people that are now free agents and that are available in the job market. So we've just come off of, in the last year, one of the tightest job markets that we all have faced in our professional careers. And if you're an employer that's looking for great people, now is an outstanding time to be active in the market, talking with folks. So we strongly encourage that. So that's the end of the update. And with that, I am pleased to introduce you all today to Mr. Brian Rogers, who's an attorney with Blue Maven Law. Brian is an outstanding attorney here in the St. Louis metro area that has a real specialty and focus on doing primarily deal transactions, buy and sell transactions. And I'm going to let Brian tell you a little bit more about that. So Brian, we're very honored to have you today and look forward very much to your presentation.
Thanks, Steve. I appreciate the invitation and happy to be here for sure. Always fun to talk about the law and business. So.
Well, you do a great job with it, and I absolutely love your presentations. I think you've got the everyman level of presentation, and you do such a great job of communicating a pretty detailed and sophisticated topic in a fashion that even I can understand, which I really appreciate.
Thank you very much, Steve. I appreciate it, and I have fun with the presentations. I do my own artwork, so for better or for worse. Definitely could never go pro selling artwork, but it makes it fun to try to illustrate my thoughts here. So I've put together I have a short presentation of a collection of topics that I've come across many times in representing many businesses over the years. And so I just compiled a few topics that I feel like every business lawyer, or excuse me, every business owner should know about the law. Hopefully the business lawyers know this for sure. So, and then at the end of the presentation, Steve and I, we're both deal guys, and so we're going to have probably an informal, more deal centered interview Q&A type thing. So hopefully that'll be of interest too. So. But the first topic is, do you own your own website? And that sounds like a crazy question, but if you hire somebody to create a website for you, they create it specifically for you, and you pay them for it, then of course you own it, right? Well, that may not be true. The law, particularly copyright law, is not intuitive in this area, and it can be pretty surprising. So let's look at a web developer. So maybe this is your next door neighbor that does some web developing on the side that you've hired. As they type along, typing code or text, marketing material, whatever they're doing for you, copyrights are in that information are automatically created, and so. So as they type, the copyrights are created automatically, and these little C's here are copyrights that in the material that they're typing away. And you would think that copyrighted material is created for you and that you own it. But the general rule under copyright law is that the author or creator owns the copyright. So your next door neighbors, they type along, they're creating all these rights in the material that are vested in themselves and not in you. So you don't automatically own that. Now there's a couple of exceptions. One is works made for hire, and the other is assignment. And you would think intuitively, well, of course this is a work made for hire. They're doing the work for me, I hired them and I paid for it. But under copyright law, the definition of work made for hire, and it's not, Steve, I might need your help. Yeah, there we go. There we go. The definition of work made for hire, so if it's something's created by your employee, it's a work made for hire, and you automatically own it because you automatically own copyright in works made for hire. But if you look at all these other categories, none of those are going to fit. They're kind of off the wall categories, really. Contribution to a collective work, part of a motion picture or other audiovisual work, translation, a test, answers for a test, atlas. I mean, none of that is going to fit your situation. So if you hire your neighbor, they're not your employee, you're not going to own your website unless you go to the second exception, which is assignment. So here we've got, again, the web developer typing away, creating copyright. And then in this slide, this next slide, can you advance it, Steve? I'm sorry. I'm not sure why it's not working for me, but we'll have to work together. Oh, there we go. Can you go back one? Everything's always more fun with Zoom. Okay, go forward one. The changes are a little subtle. You can see where the copyright's moving, but so this slide represents you, the office tower here. I'm sure you're a nice big company, or you've got some Class A space here in an office tower. So this is you. If the web developer is your employee, then as they type along, then that copyright is automatically vested in you. But if you've got say a 1099 person, your neighbor down the street doing it for you, it's not automatically vested in you. Can we go forward to that slide? So it's vested in the web developer, and then on the next slide we'll see that we need to get that copyright from the web developer to you. And on the slide after that, we'll see that the way we do it is through a contract. There we go.
Do you have control again?
I do not. It's been intermittent. Sometimes I do and sometimes I don't.
Sometimes the internet is our friend, sometimes it's not.
Yeah.
All right.
So the way to get copyright to you when it's not a work made for hire is to have a contract with the web developer. And that contract needs to have an assignment clause in it. Can you go to the next slide, Steve?
Yes.
Okay, and here's kind of a simple assignment clause. The creator, you could call it web developer, contractor, whatever, hereby assigns to the company all work product. And these two words, hereby assigns, are really important words, and those need to be in your contract. And if you'll go, Steve, to the next slide, you can see that I've underlined them because they're very important. So a present assignment of the work product created after the date of agreement is important. There's been some interesting court cases that turned on that, but to make sure that you own, everything that the web developer creates for you, you should have the words hereby assigns. And an agreement to assign the contract, which you see in some contract, agreement to sign the work product isn't sufficient. You see that in a lot of contracts. Can you go to the next slide and then the next one? Okay, so that's talking about an individual, whether it be your neighbor or your employee that you hire, but most likely you're going to hire a web development company. So here, the office tower is you. The smaller office is the web development company that you hired. And so they're going to have people actually doing the work. So as those developers, whether they're employees or independent contractors for the web developer, as they do their thing, copyright is going to vest in them. And then on the next slide, you have a contract in place with that web development company, but how do we make sure the ownership of that copyrighted material goes from the person who's actually doing the work to you? And on the next slide, we'll see that it's because you'll make sure that there's a contract between your web development company and that employee or independent contractor to make sure that the contract goes from the developer to the web development company to your company. And if you can kind of swing us through a couple of slides, you'll see the copyright go to you. So there's, I've got some kind of simplified clauses that do this. The first one deals with a situation where you're dealing directly with an individual, and you basically have put in a statement in the contract that says that all services will be provided by the creator, by that actual person. But if your contract is with a company, then you'll want one of these two next variations. So either that the services will be provided solely by employees of the creator, or solely by employees of the creator and independent contractors of the creator, with whom the creator has a written contract assigning work product to the creator. So anyway, if you do that, then you'll be covered. So it's not intuitive. Just because you hire someone to put a trademark design together for you, marketing material, website, anything that's copyrightable, in order to make sure that you actually own it, you'll need to make sure you've got a contract in place that has a good assignment provision. And so the next topic has to do with trade secrets. And trade secrets, this isn't my best work. If you go to the next slide, have mixed feelings about this one, but I was trying to figure out how to illustrate a trade secret. But a trade secret is something that has independent value, monetary but economic value, because it's not public. And also, what's key to the point that I'm talking about here, you've made reasonable, taken reasonable steps to protect its confidentiality. So often, people enter into non-disclosure agreements, confidentiality agreements, in order to have contractual protection for their confidential information. If you're disclosing information that constitutes a trade secret, you've got to make sure that the obligation to keep it confidential never ends. So a lot of times in a confidentiality agreement, you'll see what I call the period of protection, but there's a period during which the person receiving the confidential information is obligated to keep it confidential. That might be 3 years, and it's, you often include a limited time because you don't want them to be responsible for protecting information that goes stale. A lot of the information that you disclose under confidentiality agreement has a limited shelf life, and people don't want to be responsible for protecting it when it has no value. But with trade secrets, they don't have a shelf life. They never go stale. But under trade secret law, if you disclose trade secrets without adequately protecting them, then you're not using reasonable precautions to protect the confidentiality, and it could destroy its status as a trade secret. So on the next slide, we'll see that you should include a phrase in your confidentiality agreements if you're going to be disclosing trade secret information that says that it'll be protected forever, basically. So I put here until the end of time. That may be a little bit dramatic, but perpetually would probably work too. But so be careful with trade secrets, and Steve and I deal with confidential information all the time, a lot of which does it are actually trade secrets, and if our non-disclosure agreements don't take care of that, then it could be bad for our clients. So, and then the next topic is watch out for boilerplate. And boilerplate is kind of a term for the fine print of a contract, and most contracts have one section or a bunch of sections of stuff like governing law and legal fees, things that you think are just, the same in every contract. Your eyes glaze over already by the time you get to the back of the contract. And so, you don't pay a lot of attention to it. But that boilerplate language can be real important. If you go to the next slide, there's, so this is a cruise ship. I came across a case a few years ago that was decided in Missouri that just really brought home to me how important it is to be aware of what's in the back of the contract in that boilerplate. So in this case, this company had booked a large number of tickets for their employees and their families for a European cruise. and had committed, spent a lot of money on it. And this cruise was going to take place in a few months. And so they were smart enough to think, through potential scenarios. Well, what happens if we can't take the cruise what if a war breaks out or something like that? And so we've got to cancel. And so they actually negotiated a written document that the cruise company gave to them that gave them a right to refund in those sorts of situations. And so, they were satisfied. Then the cruise company presented them a contract. They signed it, and they were ready to go on the cruise. But before then, 9/11 happened, and they couldn't go on the cruise. People were, understandably, their employees were canceling, and so they were just going to be out of a lot of money. But they had this warranty, so they tried to enforce that. The problem is there was a boilerplate clause in the contract. We see it really common. Technically it's called an integration clause. More colloquially and normally you'll see it'll say like entire agreement if there's a title on the clause. And if you go to the next slide, Steve, the entire agreement clause basically says that this contract contains the entire agreement between the parties and supersedes all other agreements. Well, that simple little clause in the contract completely took away the warranty that they had specifically negotiated, because that warranty didn't find its way into the final contract. And under contract law, you're not permitted to look at evidence outside of the contract if the contract isn't ambiguous. So they ended up losing all their money, even though they'd negotiated a right to a refund under the circumstance, and it was just because of the boilerplate. So, it's something that I am probably more on the lookout for my clients more than maybe they're looking out for themselves. But those little clauses in the back of contracts can be pretty important. So you should at least pay attention to them. And then the next topic has to do with personal liability. And Steve, if you can go to the next slide. So this is my illustration of the corporate shield, the corporate veil. Most business owners, well, I shouldn't say most, but a lot of business owners do business through an LLC or a corporation because they want to protect their personal assets against the liabilities of their company's operations. And so, and they're very effective in doing that, but you've got to be careful to protect that shield. Can you go to the next slide, Steve?
Ryan, I think this is artwork that's sellable here.
Oh, thanks. So, so your company's, you're having your LLC or your corporation in place is really effective, but there are some circumstances that you should be careful about. I've seen a number of people file a fictitious registration for a DBA with the state, and they do it in such a way that it really could leave them personally on the hook for the company's liabilities. So let's say, my company is Acme Brick Company, but I don't want to do, that's such an old passé name. I want to do business under something a little more modern, like, Blue Maven maybe. And so I file a fictitious name registration. Most states require you by law to file with the state if you're going to do business under any name other than your company's legal name. And so on the form in Missouri, if when you file this fictitious name registration, there's a place for the owner of the registration. And so I've seen a lot of business owners put their own names as the owner of the fictitious name rather than their company's name. So when I'm filing my Blue Maven fictitious name, I put as the owner Brian Rogers instead of Acme Brick Company. Well, while I'm doing business, if someone say slips and falls in my store, and then, you know, which has Blue Maven on the door, it's not clear whether that business was being operated by me as a sole proprietor or by Acme Brick Company. And there've been actually, I came across a case in Missouri a few years ago where a business owner actually ended up with liability because of this very situation. So this is one example of you know, being careful about your business, but you know, being aware of ways that your liability shield may not be effective is pretty important.
And if in fact somebody has registered it that way, is it a pretty easy fix to go in and change it?
Yeah, it's really simple. I mean, in Missouri, I don't know. I think your audience is not limited to Missouri at all. But in Missouri, it's super simple. You can cancel the one, and then you can file another. You know, filing fees in Missouri are $7. You can do it online yourself, or you can mail it in from a form that you get off the Secretary of State's website.
Excellent.
And then also, kind of on the same reasoning, I see a lot of contracts that are signed by people either, you know, on behalf of their business, either without even signifying that the business is the party to the contract. They just sign it in their own name without, you know, being clear that it's actually the company that is the party to the contract and then or themselves. More often, the company name will be there, but they will sign the contract and put owner by their name. And that makes it less clear that they're operating as an agent of the company. And so on the next slide, I'll have a kind of a no-no signature block. So if I sign a contract on behalf of my law firm, Blue Maven Law, I don't want to put owner as my title. But if you go, Steve, the next slide, and then the next one. Here's what we'll want, your actual title. So it's the, you know, someone who has authority to sign on behalf of an LLC, I'm going to be either the manager or the member. Or if my operating agreement provides for officers, I might be the president or some other officer. But it's important to really clearly show in the signature blocks that you're signing on behalf of your company and not yourself, and also show the capacity in which you're signing that contract. And I believe that's the end of it. So, so I'll throw it back to you, Steve.
Well, excellent. I've got some questions. It is simple stuff, Brian, and you're absolutely right. I think particularly on confidentiality, I think that's the number one issue that we face, the number one question that we get for folks that are interested in selling their business, and then for buyers. You know, even people that are looking to buy businesses are curious about what level of information can they ask for. So Brian, would you be willing to elaborate on that a little bit and talk a little bit about how to effectively handle confidentiality, particularly if you're contemplating a transaction at some point?
Yeah, as a seller, of course, you know, before you divulge any sensitive information at all, any non-public information, you should have a non-disclosure agreement or a confidentiality agreement. Those are two names for the same document, basically, that requires, you know, the person that you give the information to protect it. There's two main restrictions in the confidentiality agreement. One is to protect it from unauthorized disclosure, to keep it confidential, and then the other is to only use it for limited purposes. So, you know, you'll want to limit the person's use of this information to just evaluating your business as a potential transaction. But even when you have a non-disclosure agreement in place, it's important to think about the fact that you, in the course of a deal, are disclosing, in some cases, super sensitive information that could really be detrimental to your company. And we see this, it's a bigger concern when you've got a strategic acquirer who's basically a competitor of yours. So, you know, someone who's in the same business, who's wanting to enter into your market, or maybe, you know, buy up smaller competitors, that sort of thing. You know, you can't unring the bell. Sometimes when you give someone super sensitive information, particularly if it's a competitor, if the deal doesn't actually close, you could be in a vulnerable position in the future, even if they abide by the non-disclosure agreement. So non-disclosure agreement is basically going to give you a contractual protection and a right to sue for breach if they misuse your information or divulge it in an unauthorized way. But it's important to think about what information they really need at a particular point in the transaction, and stage the disclosure of the information so that the most sensitive information is disclosed at the end when deal certainty is much higher. So I don't know statistics on how many deals actually close as a percentage of potential buyers that actually sign non-disclosure agreements and are given sensitive information, but I know it's a very small percent. So, you know, in any particular deal, you might end up with, you know, multiple potential buyers that you want to negotiate with, either at the same time or, you know, sometimes one after the other. And so you'll end up giving your information to more than one. And so you'll end up with, you know, these potential buyers that don't buy your company. And if you've just given them every bit of information about your company, no matter how sensitive, then you're going to be more at risk than you would be if you'd staged the disclosure to give them what they need when they need it. And we've had, I mean, sometimes I've had deals where you don't disclose some information until closing. It's just too sensitive.
Even immediately post-closing, after all the documents are signed and the money's changed hands.
Yeah, exactly. And there's other methods. I mean, you know, sometimes you can disclose to a, say, attorney or a CPA who has their own fiduciary, professional, and contractual obligations to keep it confidential. So you'll disclose it to a professional on the other side to verify what you're saying without actually giving that information to the other side. You can also use redaction. I mean, you know, people need to know, say, the top 10 customers by sales volume, maybe. Well, you know, the identity of those customers might be really sensitive, so you can redact the names of the customers, maybe give them a code, A, B, C, D, or whatever, and then give them the actual customer names at closing. So it's important to think about, you know, that information, and, you know, exactly when and how you disclose it. And always, you should never just think, oh, we've got an NDA in place, I can just give them everything.
Can you also touch on, Brian, I think there's some confusion around who is covered in the NDA. So if you're selling your company and I sign a non-disclosure agreement, can I talk to my wife about it? Can I talk to my accountant about it? Can I talk to my attorney about it? Who am I allowed to discuss the information with, and who am I not allowed to discuss the information with?
Yeah, so that's a good question. So you obviously are on the hook for information that is given to you. And, you know, the NDA is probably going to be between, you know, the buyer's, the actual company, maybe one or more of the principals of the company, the owners, but not their employees, not their lawyers, not their banker, their business brokers. And so, but these people, at least some of them are going to need access to at least some of that information. And so can you disclose it to them? Most NDAs will have a clause that permits those types of disclosures. You know, there's different ways of kind of degrees of protection. You know, usually it'll be limited to, you know, employees and advisors on a need-to-know basis. So you're only limited to giving them information that they really need to know to help you evaluate the transaction. And then generally you're going to be limited to disclosing information to people who either have a contractual obligation not to disclose it. So for instance, a lot of companies have non-disclosure agreements with their employees that would cover the situation. So those employees are already under contractual obligations to protect information that is owned by their employee and also that their employer has an obligation to protect. In my case, I'm covered by fiduciary obligations and ethical obligations. So it's very rare for people to insist that I sign a non-disclosure agreement because if I breach confidentiality, I would lose my license. So I've got a lot at stake, and people normally view that as enough protection. But so people who need to know, employees, advisors, and then also you should also keep an eye on what kind of obligations they have to keep that confidential.
Yeah, you talked about a minute ago, you weren't familiar with what percentage of the deals actually get closed, right? So the International Business Brokerage Association statistics say approximately 20% of deals that get signed, so therefore, letters of intent or some form of an agreement to transfer ownership, only 20% of those ever end up actually closing. So,
Wow.
If you think about that, it almost it's almost frightening, if you will, how much information can be out there.
Mm-hmm.
Talk a little bit about, Brian, you and I think feel a lot the same way in this regard, but when's it, we're big believers in having a deal team, whether you're selling to somebody you know or to somebody you don't know, right? Or you're transferring even to a family member. Mm-hmm. It's important to have a deal team involved. Can you speak to that? Why you think each party should have a team on their side, and then at what point do you think it's appropriate for the teams to get involved?
Yeah, definitely. Most of my clients, even sell-side clients who have run their businesses for 30 years, have entered into innumerable contracts and have had tons of business negotiations. They've never bought or sold a business, and it's a completely different. It's completely different. They feel off balance often. And it's certainly not what they do from day to day. And so having, qualified professionals to help them with various aspects of doing that transaction is, it's really important. Attorneys obviously are important. Having a CPA or somebody who can help you look at the financial performance and understand the financials, to dig in deeper behind the financials to verify that the numbers actually are good numbers. And obviously from a seller's point of view, having a business intermediary, business broker to help with getting your company ready to sell. Often there are a few things that you could change and improve, especially if you have a few years to get old inventory off of your balance sheet, old AR off of your balance sheet that's not collectible. I mean, there's often things that you can do that can increase the value of your business. And then also just knowing the value of your business. When Steve and I first met, actually we were introduced by a CPA who brought us into a deal at the same time. So I guess we met at across from each other at the conference table. And this, it was a sell side client and the exiting owner had been generating quite a bit of interest. It was pretty impressive, just, you know, unsolicited interest coming out of the woodworks. Steve looked at, you know, I think it took about 5 seconds to look at the company and realize that these offers were just wholly inadequate. I mean, they didn't even capture half the value of the company, and he was able to sell the business for, I think, what was it, twice, Steve, what they originally thought the business was worth. And you know, it wasn't just a matter of seeing the correct value, but also going through a good process to identify potential acquirers, and then you know, lead the process of getting offers, vetting them, and negotiating the final purchase price. I mean, that kind of stuff. It's not my thing, for sure. I mean, that's not the kind of thing that I do, and I feel like someone's missing from the team, for sure, if there's not a professional on the team that can help with those sorts of things. As far as timing, you know, the earlier the better, for sure. I said, you know, if you've got 3 or 5 years before you're going to sell your company, there's a lot you can do to increase the value of your company. So, you know, getting advice even that early on can be really helpful. I know for myself as an attorney, I'm often brought in pretty late in the game. I would say the most typical time that I'm brought in is right after a letter of intent has been signed. Now, it's not unusual at all for me to be brought in very early, even years ahead, or while the letter of intent's being negotiated. But often, you know, the actual deal in principle is going to be memorialized in some kind of a document that's non-binding. And a letter of intent is the most common form that takes. And I think a lot of times people think, well, this is a non-binding document, and so it's not important to get legal advice on that document. And so we'll wait and bring in the attorney after that sign. And I've had a number of negotiations that were really hampered. We just kept being hammered on this non-binding letter of intent because those documents anchor your negotiations. And so if there's something that you know, could have been in there, or even worse, something that the other side had put in there that you know, my future client didn't appreciate, then it can really hurt your negotiations later on. Probably the worst example that comes to mind, I had a sell side client who was selling his business, had signed a letter of intent, and it included a very low cap on liability. This actually was a buy side client, very low cap on liability for the seller. And so even if the seller had sold a completely subpar business, anything short of fraud, my client wasn't going to be able to recover anything more than what fell within this cap. And we tried hard to get that changed, but they stuck to their guns, and my client ended up having to either walk away from the deal altogether or accept that low cap. And you know, it was much lower than market. I think it would have been very easy to negotiate if we didn't have a signed document that was anchoring our negotiations.
Yeah, you're so true in that regard. That's all of those things that you've pointed out are key things that I think people miss. And I definitely agree with you. Getting your team gathered and getting the appropriate professionals, and I'd like for you to talk a little bit about that, because you know, certainly in the legal field there are people that specialize in a lot of different things. There aren't a lot of people that specialize in transactions, but I believe firmly that it's a specialized nature. So I'd love to have you discuss that. But I would like to just point out, you know, in my experience of 15 years in doing this, I think a lot of sellers and a lot of buyers try to minimize their expense. And, you know, they're cognizant of how much, because they're having to write some checks to get to the finish line, if you will. And they're cognizant of how much they're spending, and they try to minimize that expense. But I think the example that you gave where we met each other, I mean, it was an outstanding example of a business owner who had spent his life building a business, had offers in hand, 7-figure offers in hand to sell his business, was absolutely delighted with the offers. And, you know, had he not brought a team in play early, he would have left 50% of the available money to him on the table, right?
Yeah.
And as you said, you know, we ended up doing the transaction for a little more than twice what his best offer was at the time. And, you know, at that time, as I recall, he brought us in to evaluate his offers, right? And really take a look at, is he in a good position? And that was a situation very much like any others. There were some things that needed to be cleaned up and make sure that, you know, we properly segregated personal assets from business assets, and make sure he wasn't selling things that were near and dear to his heart as well. So I think you hit the nail right on the head. It's so important to bring the professionals in early. And I have never seen a situation where it hasn't benefited both the buyer and the seller, where in the long run, they've saved more money by having better counsel at the table. And in some instances, even made the deals go, you know, faster and smoother, just because they had the right people at the table, rather than, you know, bringing in a divorce attorney to try and put a deal together.
Right. Yeah.
So if you'd speak to the specialists kind of that a little bit, I'd be very appreciative as well.
Yeah, there's definitely, you know, every attorney, every CPA has their, you know, area of focus and their own capabilities. You know, doing deals is kind of a you know, specialized type of law. It's a specialized type of accounting. So if you know, bring in the wrong type of attorney who doesn't understand deals, it can hurt the deal in a couple of ways. One is it literally can hurt the deal, because sometimes people, you know, come into a deal like a bull in a China store. Yeah, I think that's how it goes. China store. Bull in a China cabinet would be really destructive.
A China shop, anyway.
Yeah. So, but anyway, they just trash your deal. And I mean, you can't talk to, I can't talk to any deal professional, you know, any broker, investment banker, who doesn't have half a dozen horror stories at least of counsel either really, you know, being difficult in a way that wasn't productive, and increasing everybody's stress and expenses, or in some cases actually destroying deals, because for no good reason. It was a good deal that should have been done, even if they were bringing up some things that should have been discussed. They didn't keep you know, the big picture in mind and work toward actually closing, and they just destroyed the deal. So there's also the matter of you know, subject matter expertise. I mean, there are things about mergers and acquisitions that are just different from any other, you know, contract or commercial relationship. So you know, for one thing, if you're representing a seller as an attorney, you know, one of the things that I focus on is making sure that when the seller walks away after closing, that they don't have any, you know, lingering potential liabilities out there, any more so than they absolutely need to have. And it's customary in asset purchase agreements, stock purchase agreements, for the seller to limit their liability in various ways. And I mentioned a cap on liability earlier. Very, very common provision. The problem with the cap in that transaction I was talking about isn't the fact that there was a cap. It was that it was so low, it was unusual, very out of market. And so, you know, as a seller attorney, if I were just a commercial attorney, I might or might not appreciate the fact that I can limit my clients' liability, because you can do so more in a M&A transaction than you can in a commercial transaction, just a regular contract. So another thing is in Missouri, I come across this quite a lot, but in Missouri, when you have vehicles that are being sold as in a business sale, that's a tax-free transaction. So normally in Missouri, you pay sales tax when you buy a vehicle. But if you buy a vehicle when you're buying a whole business, that's a tax-exempt transaction. Well, the Department of Revenue is not going to return your money because you pay taxes and didn't owe them. So I've, over the years, have saved my clients a lot of money on just sales taxes for vehicles that they've acquired, because I, make sure that that it complies, the transaction complies with the state law requirements. But I would venture to guess that the average business attorney in Missouri would not know that it's tax exempt. So as a buyer,
we both have examples of that. We know that for a fact that most of them don't, right? So unless you're dealing with a specialist, very often that's one of the small details that gets overlooked.
Yeah. So there's plenty of ways. I think I think things. Well, deals they're not your normal business. They're just different kind of animals, and the professionals that you bring into deals, ones that have the experience and the knowledge to do that are, generally going to be the better choice if you're looking for counsel, if you're looking for CPAs. So there are accounting points too. Deal accounting is different from your average tax accounting. And so not every accountant has a good appreciation of, structuring deals in tax efficient ways and that sort of thing. And so you could leave a lot of money in Uncle Sam's pockets that you didn't need to, if you don't have a good deal CPA.
100% correct. And that is one of the things that you can control up front. Sometimes it takes a little more time than you'd like, but you definitely have the ability to control that and make some choices up front if you have the knowledge to do so.
Mm-hmm. Yeah, there's a lot of techniques from deal structure. The worst situation is where you've got a C corporation that's selling, most transactions are structured as an asset sale, and when you do that, it creates a lot of tax liability in that corporation. And there's ways of minimizing that in a lot of instances that can really, really reduce your taxes that are, even among deal attorneys, maybe not widely known. So that's another reason it's a good idea to have a full team. And I always feel if there's somebody missing, if there's not an intermediary, if there's not a CPA or there's not an attorney on the other side, I always feel less comfortable with how everything's going.
Yeah, unquestionably, we're the same way. We are strong advocates of putting together a team, no matter which side of the table you're sitting on. And it's, it goes, I think it's just common sense that those that have a team, we see this all the time, that are faced with those that don't have a team. And it's particularly a seller who gets an offer that they think is very attractive, and they end up signing basically whatever gets put in front of them because they're trying to save some money on transaction costs. And a savvy buyer on the other side who is, maybe buying every printing company in the area, right, and trying to do a roll up, and the seller ends up leaving money on the table and potentially, leaving themselves open for all kinds of clawbacks that they're just not aware of at the time. They just don't know what they don't know.
Yeah, absolutely. Also, if I were selling a business, I would not do it without a broker. Not just for those reasons, but it's hard to sell a business. Finding a good qualified buyer, especially the best one that can pay the actual value, the real value of your company, is no easy task. you know, you pay a bit of money for it for sure, but I don't have confidence that I could sell a business, you know, my own business, and I've got decent network, you know, of folks that I could, you know, try to find buyers, but you really want a professional who's in the business of finding buyers for businesses.
Definitely gives you an advantage, no doubt. Brian, also talk about one of the most common questions we get is why does a buyer always want to do an asset purchase instead of a, you know, a seller always wants to do a share sale because it's so easy to hand the keys over and walk away. But buyers always want to do asset purchases. Why is that?
Yeah, there's two main reasons. So basically, most business sales are structured in one of two ways. The simplest way, like you say, is just to sell the stock, or if it's a limited liability company, you sell the membership interest. So, you know, your LLC owns all the business assets. So all you have to do is sign over. It's one simple document, not that any well-negotiated membership interest purchase has one document, but the actual transfer is super simple. Just assign your membership interest to the buyer, and it's done. The other way is to leave the LLC intact with its owners, but basically take all the assets out of that company and transfer them to your own company, the buyer's company. And that's usually known as an asset sale. And that's by far the most preferred in my market for sure. The deals that I work on are almost always asset sales. And the two main reasons that particularly buyers want to do that, one is you can leave the company's liabilities behind. So as a general rule, when you buy a business, the only liabilities you're going to take on of the seller are those that you expressly agree to take on. And so so you can leave, you know, any potential slip and fall issues that happened, you know, potential, you know, personal injury plaintiffs that you might not know about. You don't have to worry about that risk because that'll stay back with the seller. The other is taxes. There's a very significant tax advantage to buying assets as opposed to buying the stock. And it basically comes down to what's known as a step up in basis. And, you know, basis is basically your, boy, this
Your
is
investment amount, your original investment amount, right?
yeah, having me explain a tax concept maybe is the smartest, but it's yeah, basis is basically you can take deductions for say your equipment in the amount of the basis that you have. And so when you buy a business that has depreciated assets, that basis is going to be low, maybe zero. And so the available deductions to the seller might be non-existent. But when you buy those assets, the basis gets marked up to the fair market value of those assets at the time of sale. So you basically get to reset the basis, and that gives you a lot of new tax deductions that you can take. So it's very good for buyers. So.
Yeah, excellent summary. Well, we're right up on the hour, and we did get one question, and that is the question was related to PPP, and they're saying yes, the PPP actually closed on the 8th of August, and that is correct. I misspoke earlier. So thank you very much for pointing that out. It's an outstanding audience that we've got here. Or I should say there is provisions because of the fact there was $130+ billion left when the window closed. There was provisions in the next form of legislation to keep that lending window open. We'll see when Congress gets back whether or not they elect to do that. So yes, the viewer is absolutely correct. I misspoke. The PPP window did close a little earlier this month. So Brian, excellent presentation. Any, what's the best advice that you would give to, we're in a position now where we had a guest a week or so ago talked about the silver tsunami that's coming. And basically what he meant by that was, the baby boom generation coming back from World War II really were the business owner entrepreneurs that were unprecedented in history in terms of numbers. And many of them are now my age and older. And they're, certainly at or beyond what is considered common retirement age, right? And at some point in time, there's this thought process that there's going to literally be millions of businesses that will be available with all us silver-haired folks wanting to quit working for a living and retire. So this silver tsunami is coming at some point in the future. What's the key piece of advice that you would give to a baby boomer that may be on the end of their career and is beginning to contemplate selling their business? What do you think? What do you think you would advise them to do?
I would say, for one thing, I've talked to a lot of people who are planning on just shutting their businesses down. They don't realize that they might have a saleable business. I think you should think about, how saleable your business is and what it's worth. In a lot of cases, people can vastly increase the value of their businesses if they've got a little bit of time. So that you can take a business that might not be saleable today, make a few adjustments, and it'll be saleable in 2 or 3 years. Or you could have a business that's worth $1 million today, and you make a few adjustments, and it's worth $2 million in 2 or 3 years. And so I would think about your business, whether you can sell it, and how can you increase the value of that business. So, and 2 of the main ways that you can do that are to make yourself not make yourself dispensable. If you're as the owner are indispensable to the company's operations, then that's going to limit the saleability of the business. And the other is, potentially growing the business either by an acquisition, a small one even, because if you have 2 businesses and one is larger than the other, the larger one generally is going to be more valuable than the smaller one. More than, if a business is one business is twice as large as the other, the increase in value is more than twice. So being bigger actually gets you more per dollar of revenue, basically, or income. So
in many instances put you into a whole new ballpark.
Yeah,
it takes you from the minors to the majors, no doubt. I think that's excellent advice, and I think it's been an hour well spent, Brian. We're very indebted to you. I think you've got a great presentation. I love your artwork. You may not be able to sell it, but boy, you captivate me every time you put it up there. I really like it. I think your point about being a specialist is really important, and having the deal team involved early in the process. I hope the audience can see from Brian's knowledge that you get the right professionals on your team. They're going to make you money. They're not going to cost you money. They're going to make you money. So I think it's really, really an important thing. Brian, again, we're in your debt. Thank you very much for giving us the hour. You're an outstanding professional here in the market. We're blessed to have you, and keep up the good work. So thank you.
I really appreciate it. It's been a pleasure for sure.
Outstanding. The pleasure's all ours. And folks, make it a great week, and we'll look forward to seeing you again next Thursday afternoon. Bye-bye.